Good morning. Today, I will be evaluating the considerations taken by the courts in determining the application for postponement of possession order in the absence of concrete evidence from the mortgagor. The general rule is that legal mortgagee has the right to go into possession of the mortgage property before the ink is dry, as stated in the case of Formates Limited and Dudley Marshall Limited. This means that a mortgagee has unqualified and/or absolute right to possession of the mortgage property, which arises as soon as the mortgage is made and not dependent on any default by the mortgagor. But usually, the mortgagee will not exercise this right. The mortgagee will usually make a contractual promise not to seek possession unless the mortgagor defaults on the repayments or breaches some sort of obligations. It is worth noting that if such defaults occur, the right to take possession may be obtained in virtue of the right of the mortgagee, not in virtue of a remedy to be asked for from the court, which means that an order from the court is not required. Initially, where a mortgagee sought possession of a mortgaged land in order to protect its interest, a mortgagor could apply to the High Court to have that possession postponed for up to 28 days only if he could show that the whole of the mortgage debt could be paid off within that time, as stated in the case of Birmingham Citizens Permanent Building Society and Con. It was also stated that generally, courts have no jurisdiction to decline the order or to adjourn the hearing, whether on terms of keeping up payments or paying arrears if the mortgagee cannot be persuaded to agree to this course. As a result of this case, the Paying Committee on the Enforcement of Judgment Debts was directed to consider whether the courts should have the power to postpone the operation of an order for possession of mortgage property, in which the committee reported in favor of this power. The recommendation of the Payne report has led to the enactment of Section 36 of the Administration of Justice Act 1970 to mitigate the harsh rule decided in Con, as a mortgagor now has certain protections under his act in situations where a mortgagee would bring an action to take possession of the dwelling house. Section 36, subsection 1, states that where a mortgagee under a mortgage of land which consists of or includes a dwelling house brings an action in which he claims possession of the mortgage property, the court may exercise any of his powers conferred on it by subsection 2 if it appears to the court that in the event of his exercising the power, the mortgagor is likely to be able within a reasonable period to pay any sums due under the mortgage or to remedy a default consisting of a breach of any other obligations arising under or by virtue of the mortgage. This was followed by Section 36, subsection 2, which provides that the court may adjourn the proceeding or, on giving judgment or making an order for delivery of possession, or at any time before execution of judgment or order, may stay or suspend execution of the judgment or order, or postpone the date for delivery of possession for such periods as the court thinks reasonable. Furthermore, subsection 3 states that any such adjournment, stay, suspension, or postponement as referred to in subsection 2 above may be made subject to such conditions with regard to payments by the mortgagor of any sum secured by the mortgage or the remedying of any default as the court thinks fit. Section 36 applies to dwelling houses, and to determine whether the property falls within that category of dwelling house, it was stated in the case of Royal Bank of Scotland and Miller that it is to be determined by the courts through reference to the state of the premise at the time the order for possession was sought, and not when the legal charge was entered into. It is worth noting that since Section 36 was enacted to provide the court with the power to refuse or suspend an order for possession, it is not intended to extend to the case where the lender exercised his common law right to take possession by peaceable entry without seeking possession order from the court. This was argued in the case of Mortgagor and Barclays Bank, in which it was held that it was lawful for the lender to take peaceable entry without seeking possession order. This can be seen as a limitation of this act, as this application can only be used at the discretion of the court if an application of an order of possession has been made, which means that if a mortgagee takes possession without a court order, the court would have no jurisdiction to suspend the possession, as there is no indication in the section that would restrict such rights. Another limitation of this act is that it is only available to those mortgagors who have the financial means necessary to meet the affordability test established under this section. Any other factors, including the presence of children, disability, ill health, or relationship breakdown, do not feature within this legislation. Section 36 was intended to give a mortgagor of a dwelling house who had fallen into temporary arrears with installment a reasonable time to catch up. But since most mortgages had the effect of rendering the whole sum due on default through the default clause, which is inserted into the mortgage, this can be said to have deprived a mortgagor of the protection which the Act was intended to give, which was to provide him a reasonable time to clear the mortgage arrears. The terms any sums due under the mortgage in Section 36, subsection 1 had been interpreted in cases such as in Halifax Building Society and H.L.R. to mean the whole sum of the mortgage, which can be said to significantly narrow its application. This has led to the enactment of Section 8 of the Administration of Justice Act 1973, which interpreted any sum due as meaning any sum outstanding at the date of the hearing which the mortgagor would normally be expected to have paid. There is uncertainty as to whether additional costs such as fees, administrative charges, and interest on the arrears constitute as any sum due. If it does, it can be said that the jurisdiction is less helpful as the hurdle facing the borrower is higher. In Santander and McAtamney, it was determined that the only relevant sum due for the purpose of Section 36 was the arrears on the current debt and not any additional charges. However, this case only has persuasive authority in this jurisdiction. It has been said that this legislative change was initiated by the concern that customers who acquire goods or services on credit are not in position to exercise a true freedom of contract, because the law does not protect them from unconscionable provisions. This was illustrated in Hastings and Tenant Society and Goddard, where the terms of the mortgage gave the lender an absolute right to possession if the borrower defaulted. The Court of Appeal refused the request to delay, as the only way in which the possession order could have been resisted was to redeem the whole mortgage, evidently a difficult feat for the mortgagor to achieve. The court in the case of Bank of Scotland and Grimes had considered the effects of these two sections, where it was stated that the intention of both sections is to give a measure of relief to those people who find themselves in temporary financial difficulties, unable to meet their commitments under their mortgage and in danger of losing their homes. This case had also established that this statutory relief applies equally to repayment mortgages and endowment mortgages. The Administration Justice Act 1970 and 1973 does not only protect the interests of the mortgage, but the mortgagee as well, through the requirement that the mortgagor needs to show evidence that the debt could be recovered. An example of this could be seen in Town and Country Building Society and Julian, in which the Court of Appeal refused to exercise their discretion because the defendant could not show the outstanding arrears would be met. Although it may be considered unjust to exclude the application of the legislation where the mortgagor is not capable of making repayments within a reasonable period, it can be regarded as necessary since the rights of the mortgagee also have to be taken into account. An intended sale of the property by a mortgagor could be one of the factors that could justify suspension of a possession order under Section 36, but there must be a firm evidence that the sale is likely, not that it might occur or the mortgagor will now take steps to secure the sale. However, in the case of Cheltenham and Gloucester PLC and Crowds, it has stated that it does not apply to a case where a mortgagor could show that he has personal funds to meet any shortfall caused by negative equity. Thus, the mortgagee's possession could not be delayed to allow the mortgagor to make an application for the sale under Section 91, subsection 2 of the Law of Property Act 1925. It can be seen that these statutes have diminished the impact of the draconian common law rules by shifting control away from the lender and into the hands of the court. This has been achieved by the legislation, as the courts are no longer forced to give effect to the terms of the mortgage. Instead, the Administration of Justice Act 1973 ensures that the court's jurisdiction extends beyond this, so that a default triggering the mortgagee's absolute right to possession can be prevented. This was demonstrated in National and Provincial Building Society and Lloyd, whereby Section 8 operated to allow the Court of Appeal to exercise their discretion so that it could be determined from the mortgagor's financial situation whether it was appropriate to grant a possession. Even though it was included in the contractual agreement that the whole of the loan was repayable in the event of the default. From this case, it can be seen that these two acts have provided adequate protection since the mortgagee can no longer insert a default clause which predetermines the mortgagor's capability of recovering the debt. Such a term in the mortgage aimed to circumvent the application of the legislation by putting the mortgagor in an impossible situation either to repay the whole sum borrowed or to recover the debt through the sale of the property. This prevents unfair results as again seen in Halifax Building Society and H.L.R, where even if the mortgagor fails to make 2 consecutive payments, a default clause could still prompt repayment of the whole sum, which would subsequently give rise to the mortgagee's right of possession. The Act uses the word likely, and whether the mortgagor is likely to pay the sums due can be said to be a question of fact to be decided by the judge on the evidence as stated in the case of Royal Trust Company of Canada and Markham. Another crucial question which has to be answered in every case is what is a reasonable period, as it is not properly defined by the Administration of Justice Act. Many cases have developed in determining as to how this discretion was to be exercised. In the case of Centrex Trustees and Ross, Golding Justice state that in assessing how long a reasonable period might be, the court must bear in mind the rights and obligations of both parties, including the lender's right to recover their money by selling the property if necessary, and the full past history of the security. Another arbiter which relates can be seen in the case of First Middlesbrough Trading and Mortgage Company Limited and Cunningham, whereby Scarman Lord Justice, when considering what is a reasonable period within Section 36, he stated that since the object of the installment mortgage was, with the consent of the mortgagee, to give the mortgagor the period of the mortgage to repay the capital sum and interest, one begins with a powerful presumption of fact in favor of the period of the mortgage being the reasonable period. Furthermore, in Western Bank and Schindler, Bucky Lord Justice stated that what must be reasonable must depend on the circumstances of each case. In a suitable case, the specified period might even be the whole remaining prospective life of the mortgage. A more lenient approach was taken in the case of Cheltenham and Gloucester Building Society in Grant. Here, the Building Society unsuccessfully challenged the common practice of district judges exercising their discretion under the Administration of Justice Act 1970 without hearing sworn evidence from borrowers. And it was stated here that it must be possible for judges to act without evidence, especially where, as here, the mortgagor was present in court and available to be questioned, and no objection to the reception of informal material is made by the mortgagee. Clearly, it will sometimes be prudent for the mortgagor to put in an affidavit before the hearing. So to summarize, the Court of Appeal in this case had declined to lay down rigid rules as to how judges should satisfy themselves as to the requirement in Section 36 and upheld the original order made by the district judge that a possession order should not be enforced without leave of the court while regular payments were made. This lenient approach, along with arbiters in Ross, Cunningham and Schindler, were all followed in the case of Cheltenham and Gloucester Building Society and Morgan. Here, the plaintiff had mortgaged a home to the Building Society as security for a loan of £90,000 which she used to fund her husband's business. Under the terms of the mortgage, the whole amount became due and the Building Society sought a possession order. The arrears had also increased substantially as this was stayed on more than one occasion. It was established here that factors such as the amount a borrower could reasonably afford to pay both now and in the future, if he has temporary difficulty in meeting his obligations, the reason for the arrears which had accumulated, the amount remained for the original term, the relevant contractual term, and the type of mortgage could all be considered when determining reasonable period. In this case, it was stated that by spreading out the period of repayment, the mortgagor would be likely to pay off his debt. This case is more important as prior to this decision, the courts had become too rigid with their practice relating to the mortgagee's request to suspend or dismiss a possession application under Section 36, with the courts generally suspending possession for an automatic 2 years so that the mortgagor had to make up the arrears in that time. Clearly, the notion behind this decision is that the case is that in this section 36, it should be used effectively to protect mortgages of residential property, and that the court should address all the relevant issues before deciding on whether to exercise this discretion. The guidance provided in this case of Norgan had been met with the criticisms that it fails to prioritize the relevant considerations and give the impression of being no more than a random list of relevant issues. It has been argued that the danger attendant to such a general checklist is that a mere consideration of one or more of the listed factors can be relied upon by the court to justify a desired outcome. Nevertheless, the guidelines established in Norgan have generally been said to allow the courts to decide on what is fair for the mortgagor. Although it can be said that the Administration of Justice Act 1970 and 1973 generally provide sufficient protection to the mortgagor, there are other grounds to be considered by the courts for keeping a mortgagee out of his right of possession. For example, in the case of Quinnell and Mulvey, Lord Denning had suggested that a court of equity could restrain a mortgage from taking possession whenever there was no justifiable reason for that possession. His view was that possession could be sought only for the genuine realization of the mortgagee's security. This idea has been said to go against the conventional idea of the mortgagee's absolute right of possession, and that no principle of equity must not interfere to prevent the mortgagee from this right. Nevertheless, this was seen as an alternative method in which a mortgagee might be kept out of possession. Aside from the Administration of Justice Act 1970 and 1973, courts could also use its power to postpone possession for up to 2 months under the Mortgage Repossession Act 2010, though this act only applies to protect them through a right to be heard of possession hearings, by giving the courts and judges authority to take tenants' needs into account, and allows possession to be postponed by up to 2 months so that the tenant can find an alternative home. Unauthorized tenants are able to apply to the court to delay repossession for up to 2 months, as long as the court has not already allowed an extension of time when the possession order was made, and that the tenant has already asked the mortgage lender to agree to delay the execution of the warrant and it has been refused. An order of the court could also be avoided altogether through the pre-action protocol for possession claims based on residential mortgage arrears in respect of residential property. The protocol does not alter the parties' contractual or statutory rights and obligations, but does describe the behavior the court will normally expect of the parties prior to the start of possession claims. It aims to ensure that the lenders and borrowers act fairly and reasonably with each other in resolving any matter concerning mortgages, such as providing the requirement that the borrower has to provide evidence where possible of an improvement in their financial circumstance in a foreseeable future in order to postpone suspension. So to conclude, Section 36 of the Administration of Justice Act 1970, as amended by Article 8 of the Administration of Justice 1973, has been said as a useful response for mortgagors in short-term difficulty who are likely able to cope after an unexpected setback. Courts over the years have applied the postponement of possession order in a way that goes in line with the purpose of this Act, with cases like Norgan establishing guidelines that will protect the interests of both the mortgagor and the mortgagees. Thank you.